Okay, good. Yep. All right, let's get to this. No slackers tonight. We're doing the big book, the big brief, the big whopper of essentially the United States Court of Appeals, the Fourth Circuit. They decided Gary Kirk versus the Commissioner of the Social Security Administration. Now, normally, the proper way to read a brief where basically the Social Security Administration was caught, essentially, withholding documents, withholding evidence so that the claimant could not use them in the adjudication. They got caught, and they got a slap on the hand from the circuit. But normally what we do is we read the actual brief. I don't want to do that. Tonight, we're going to do it differently. Tonight, we're going to read the dissent first. Now, what is a dissent? Well, you have a majority of judges who decide the claim in one direction. Okay? That's called the majority decision. And then the dissent is where a smaller group of judges disagree with the majority and deliver what's called the stick it to the man brief. Very important. Very important. We're going to start there because I think they did a better job outlining the details of the claim. Let's just go ahead and get our nice little bookaroo out. We're going to go ahead and scroll a little bit until we find it. I have no idea what page it's at. I saw it in here. I just got to find it real quick. We're getting there. We're getting close. Hold on. Well, did we miss it? We did miss it. Hold on. Let me get... the dissent is pretty saucy. It's pretty large. Let me see if I can find it right here. Hold on. No, we're getting there. We're getting there. I have totally, completely lost the dissent. I lost the dissent. It's in here somewhere. Hold on. We're going to find it. Oh, man. Did I really lose? Wait. Nope. Still lost it. Hold on. The dissent cannot possibly be this big. Maybe it is. Hold on. Let me scroll a little bit farther back. We're almost there. Okay. I think, nope. 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 Still not there. What the friggin' hell? Hold on. Let me go farther forward. I have no idea where the hell the dissent went. I lost it. It's somewhere in here. It's supposed to be in the back. Yeah, this is definitely the dissent because the judges are very spiced up. Hold on. We're going to get it. Give me a moment. Hold on. This is still the dissent. The judges are very hopped up on this. All right, I think we found it. I think we got it here. Hold on. I think we got it here. Hold on. One more page. Here we go. Still one more page. All right, here we go. All right, there's the number one icon. All right. So this is okay. The circuit judge dissenting. We found it. It's on page 26. It's actually, hold on. It's actually almost the same size as the decision. So my apologies. It took me a moment to find it, but now we are here. Let us begin. Let's get our Santa hats on. Let's make sure that we are jolly in reading this pissed off judge's dissent. Let's make sure that we understand that we are talking about documents withheld that resulted in a man not being able to be found disabled. Although there's a little twist to this whole pupperoo. All right, here we go. The Social Security Act sets forth a procedure known as a redetermination to address fraud. It provides that the Commissioner of Social Security shall immediately redetermine the entitlement of individuals to monthly insurance benefits if there's reason to believe that fraud or similar fault was involved in the application of the individual for such benefits. The Act is also clear about how to handle suspect evidence included in such an application. When redetermining the entitlement of benefits, the Commissioner of Social Security shall disregard any evidence if there is reason to believe that fraud or similar fault was involved in the providing of such evidence. That's 42 U.S.C. Section 405 U1B. Now, what we're talking about here, just to kind of clue people in if they're not ready, is that when the SSA believes that a doctor was fraudulent in creating documentation for a claimant, or they said that they were disabled, they are allowed to, under this rule, withhold, pull back, not use that evidence. Cool. The question presented here are whether the Social Security Administration, in interpreting these statutes, delineated procedures that violated the procedural due process rights of Gary Kirk and Larry Taylor, and whether those same procedures were arbitrary and capricious under the Administrative Procedure Act. Arbitrary and capricious is a legal term of art. Let me get you an actual definition because you're going to need it for this. Hold on. Arbitrary and capricious. Well, so let's check it out. Arbitrary and capricious is a legal context, generally means a decision-making process or outcome that is unreasonable, lacking a rationale basis, or without due consideration of relevant facts and circumstances. Arbitrary and capricious is where a decision is made that's not based on things that we normally base it on, like facts, proper logic, proper analysis, etc. In other words, arbitrary and capricious means they pulled it out of their butt. Although that is not what I want any of you using as your proper legal definition. However, I do, when you refer to dissenting briefs, expect you to refer to them as the stick it to the man brief. That's pretty much what they are. All right, here we go. The questions presented here, right? Okay, did we violate the procedural due process rights? Did we violate essentially the Administrative Procedure Act? Yada, yada. The dissenting judge says, in my view, the redetermination process affords substantial due process more than sufficient to satisfy Matthews v. Eldridge and does not run afoul of the APA. Consequently, I respectfully dissent. So what does that mean? It means that the judge is saying that in this dissent, he feels that they should use the SSA system of withholding evidence that they believe is fraudulent, so that those people who used it to be found disabled can't use it as part of a redetermination. The kicker, the problem is, realistically with this situation, is that if you don't look at the evidence and study it and go into detail with it, how do you really know if it's fraudulent? And then once it is discovered to be a little fraudulent, a little not fraudulent, what do you do with it? If you just automatically pull it and say, well, we found that this doctor was doing this and we don't like the things that he said and probably biased and from fraud and things like that, we don't want to use it. Well, then how does the claimant prove that they were disabled if they relied on that evidence to show that they were disabled? Because not everybody is a fraudster that got caught up in a situation like this. William Wallace, love that name. We know exactly where that comes from. That is a Braveheart moment right there. Thank you for the $5 donation. Let me put a little heart on that. That's awesome. Thanks a lot for your info. The best on YouTube. Keep up the hard work. Just know you are doing God's work. God bless you and your family. And I really appreciate it. And God bless you as well, good sir, because I'm really hoping things get better for the American family, for the American people, because it has been rough on the class of individuals who are living on a very, very small check. And I've been pushing some politicians at the House level. And one of the weird things is that a lot of the House of Representative politicians, they're not super duper educated. They're not super duper trained in how the law works. So I've noticed that they tend to be manipulated a little bit more than the senators do when it comes to the creation of laws. So I'm just hoping we can continue to push forward to get these individuals to present bills, ideas, hopefully create laws, but it's not all up to them, that actually support our classes of very fragile people, disabled, retired, etc. Because it's just like America cannot treat its disabled and elderly like this going forward. It just can't. They can't afford it. They can't live like this. They can't. They can't. A bowl of soup is obnoxiously priced. A bowl of cereal is unconscionably expensive. It doesn't make sense. We're just punishing people who are disabled and elderly. All right. Here are the facts from the dissenting judge who wrote the Stick It to the Man brief. The facts here could pass for the plot of a John Grisham novel. Very good, yes. Aptly named Eric Kahn, a lawyer in Pikeville. Now remember, he was the famous Kentucky lawyer who basically had like 100% passage rate, an impossible passage rate. There's no way that you can win 100% of your claims, okay? Unless you perfectly chose the perfectly easy slam dunks claim every time, but then you could never make money because you wouldn't be able to do enough of them to pay the staff. So anyways, this guy, right? So you got Eric Kahn, a lawyer, Pikeville, Kentucky, conspired with 4 doctors and an administrative law judge to defraud the United States government out of millions. We're talking like hundreds and hundreds and hundreds and hundreds and hundreds of millions of dollars. Out of millions of dollars in Social Security benefits and millions more in attorney's fees. Kahn advertised himself as Mr. Social Security, which, to be fair, is a very, very sultry, sexy title. Very good. Very good. I do not have a title like that. I should have a cool title. I just don't. Dragon Beast Social Security Rockstar. I mean, not as good. Not as we will work on what my title is supposed to be. Please remember that I have a very unhealthy relationship with Social Security. I work on it in the morning. I work on it at night. It's just it's not a good way to live. So if you guys could think of what a great title, please be kind, actual Social Security title for me should be, I would appreciate that. That would be amazing. I know some of you will be horrendously mean about it. So to those of you who are already thinking of all the mean things you're going to say to me, please remember that I cry on Thursdays, mostly before lunch. All right. So here's the deal. So we got this attorney. Khan advertised himself as Mr. Social Security, inducing clients to hire him for assistance in obtaining benefits. All right. So here's the deal. To pad his clients' applications, Khan gave pre-completed template residual functional capacity forms to 4 crooked doctors who would then sign off on applicants' disabilities. And to stack the deck further, he paid off ALJ David Doherty. I mean, that was the real ticket here. The real ticket here was he paid off ALJ Administrative Law Judge David Doherty. That's the real ticket here. Who in turn funneled Khan's cases to his docket where he could rubber stamp applicants as disabled and award benefits. Under this arrangement, Khan's clients were awarded over $550 million in benefits. Sarah Randazzo, lawyer, pleads guilty in $550 million Social Security fraud scheme. It was Wall Street, Journal thing, the whole schmutz. Khan received over $5.7 million in fees, and the doctors and the ALJ were all paid handsomely. Okay, so in other words, what we have here is an efficient model for creating universal basic income. It works. It was done fraudulently, but we know now that universal basic income works. All right, cool. Here we go. Next one. Khan's scheme began to unravel when a whistleblower reported concerns over ALJ Doherty's docketing practices. So in other words, one of the internal people at the SSA was like, hey, what the F? Why do this attorney's claims always go in front of this judge? The United States Office of Inspector General, OIG, the guys with the secret, investigators, began an investigation in Hicks v. Commissioner of Social Security. So what happened was eventually Khan pled guilty to theft of government money and paying illegal gratuities. Khan then escaped to South America because, that's where bad people go. That's where bad people go, right? That's where they go to have fun. But his time there was short-lived. Police located and apprehended him at a Pizza Hut in La Ceiba, Honduras. I pronounced it wrong. I don't feel bad about it. Where he was attempting to log onto Wi-Fi. All right, so just as what did you learn from this case? Just as an understanding, okay? The bottom line is this: if you defraud the Social Security Administration out of hundreds of millions of dollars, and you flee to South America, do not use your regular accounts to log into your stuff at a Pizza Hut. Just don't do that. And I understand what you're thinking. Pizza Hut is one of the safest places because you're under the hut. It's just not. It's not. It's just not. We know that now. We see it here in the brief. Okay, here we go. Eventually, Khan pled guilty to theft. Khan then escaped to South America, located and apprehended him at a Pizza Hut where he was attempting to log onto Wi-Fi. So now we know Pizza Hut, not safe. Not safe for internet travels. Okay. Now, with that said, Khan is currently incarcerated, serving a 27-year prison sentence, as are many of his cohorts. By July of 2014, the OIG had identified 1,787 individuals, all of whom had been represented by Khan, whose applications the OIG had reason to believe were tainted by fraud. In May of 2015, the OIG informed the SSA that it could proceed with redetermination hearings, right, using their cadre thing. All right. As part of the redetermination process, in accordance with 42 USC, the SSA excluded RFC forms submitted by Khan and the 4 implicated doctors because, according to the OIG, there was reason to believe those forms were tainted by fraud because they were paid. The doctors were paid to fill out pre-done RFCs. Okay, they sign here kind of gig. Even so, the SSA reviewed those 1,787 files to determine whether there was sufficient evidence besides the statutorily excluded forms to support a disability determination. Because remember, a lot of these people that signed up with Khan, aka Mr. Social Security, they didn't know. A lot of them didn't know that they were signing up with a fraudulent practice situation. A lot of them were potentially disabled, and they got stuck in this situation where Khan had frauded the system and caused all these problems. But there was a chunk of them who didn't know. You got to be fair to these people. Of all the applicants identified by the OIG, the SSA determined that 1,500 had sufficient untainted evidence to uphold their initial benefit determinations and would therefore be subject to redetermination proceedings. So in other words, there was like 1,500 of them where, they're probably disabled back in the day. They got to check it, but they probably were. Okay. Now, James Bryan, thank you. That's a $5 donation. Absolutely love it. Put a little heart there. Walter Hnot, Disability Rex. I think that's good. I do like dinosaurs. T-Rex is one of my favorites. I did have the Barbie doll version of a T-Rex when I was a kid because back then I was a boy and that's how the world worked. But, nowadays, I don't know. I mean, I probably would have been given, I don't know, a Triceratops. That seems more culturally appropriate nowadays. I'm not sure where I'm going with that, but the 3 horns, the giant bucket head thing with the giant, it doesn't matter. Okay, it doesn't matter. Kirk and Taylor I just saw the next $5 donation. Reload did a $5 donation. Let me give a little heart right there. Thank you. The Social Security Jedi Master. First of all, I feel like I want to be on the council of the Jedi, masters, because I feel like they just kind of sit around all day and, bicker. And I love that. You know what I mean? If I just sit around and bicker all day on that sounds nice. That sounds nice. We'll see an Anakin one time. Maybe we handle it differently. We'll see how it goes. All right. So after his initial application was denied, Kirk hired Khan to represent him. ALJ Doherty then issued a favorable decision in 2009, relying on the records from one of the implicated doctors to find Kirk suffered from Arnold-Chiari syndrome, Bell's palsy, sciatica, it's really tiny font, and low back pain and had limited residual functional capacity. As such, the ALJ Doherty found Kirk's disability began in 2006, and Kirk began receiving benefits from the SSA. I mean, okay, so this is back to 2006. It's like a different world back then. You know what I mean? We were just getting finished up with Ford Excursions, arguably the coolest SUV ever made. All right. So the ones with the 7.3 diesel engine, not that other shit. All right, so Kirk received notice on May 18th, 2015 that he would be required to undergo a redetermination proceeding. As part of his proceeding, Kirk was permitted to submit additional evidence on his disability and did so. The new ALJ, however, found Kirk was not disabled as of the date he had previously been awarded benefits. Kirk requested a review by the SSA Appeals Council, which was denied. Kirk then filed suit alleging 5 causes of action, including violation of the procedural due process, the Act, and the APA. A magistrate judge heard the parties on numerous motions, issued a report and recommendation, then stayed the case pending a final decision in Hicks 2. Given the uncertainty as to how and when Hicks 2 litigation would proceed, the district court assumed responsibility for the case. After final hearing on the merits, the court found that the redetermination procedures violated Kirk's procedural due process and expressly reversed the SSA's prior redetermination decision. The SSA said F no and timely appealed. Taylor filed an application for benefits in 2010. This is the other guy. Stating his disability began in 2010, Khan served as his attorney. The agency denied his initial application and has requested reconsideration. Taylor then requested a hearing before an ALJ. Subsequently, ALJ Doherty issued a favorable decision. No surprise there because he's paid to do so. He's paid to fraudulently approve claims. So issued a favorable decision without holding a hearing, relying on a medical examination report by yet another template implicated doctor. ALJ Doherty found Taylor suffered from acid reflux, fatty liver, anorexia, and had limited residual functional capacity. Taylor then began receiving benefits. Okay, all right. So here we go. Now, Taylor, like Kirk, these are our two people in this suit. They were notified on May 18th, 2015 that he would have to undergo a redetermination proceeding, right? So they're getting checked because of the fraud, yada, yada, yada. Taylor was afforded the same process as Kirk and submitted additional evidence of his disability. At a hearing where he was represented by new counsel, the new ALJ found there was insufficient evidence to support Taylor's initial award of benefits. Taylor requested a review of the decision, which the SSA Appeals Council denied. Taylor then sued, challenging the judge's redetermination decision and the Act's redetermination procedures. Acting pursuant to 28 U.S.C., the magistrate judge, which is a higher-up judge, not the SSA judge, granted the commissioner's motion for summary judgment on Taylor's claim that the redetermination procedures violated procedural due process, the Act, and the APA. Taylor filed a motion to alter or amend the judgment. The court denied the motion, and Taylor timely appealed. Kirk and Taylor's appeals have been consolidated for our review. So we got two people claimed to be fraudsters. Well, the attorney was, and the attorney basically submitted essentially their residual functional capacity forms to doctors who signed off on it when it was a pre-filled out form. They got a hook in with Doherty, a judge that basically was paid off. And now we're going ping pong back and forth with the court over whether or not the evidence should be considered in part or completely removed from the record. Kirk and Taylor argue. The majority agrees that the SSA's redetermination procedures violated their procedural due process rights. Specifically, so just the majority agrees. So this is what actually happened. The majority said, yes, the SSA effed up. They should have allowed these individuals to be able to review and use and properly assimilate more of this medical record into their file, okay, as opposed to just a full pull, right? Specifically, they challenged the Act's exclusion of evidence from Khan's co-conspirators. Even though they had noticed an opportunity to contest the subsequent termination of their benefits, they insisted it was unconstitutional to exclude their suspect evidence without giving them an opportunity to argue that in their cases. The OIG had no reason to believe their RFC forms were fraudulent. To begin, while I reach a different conclusion, this is the dissenting judge, I agree with the majority in the district courts below that Matthews is the proper framework for this inquiry. Matthews provides that at the most basic level, due process is the opportunity to be heard at a meaningful time and in a meaningful manner. Okay, so that's how they define due process with this situation, right? In evaluating this requirement, there is neither a set form of hearing required under due process nor technical conception with a fixed content unrelated to time, place, and circumstances. Now, Matthews has long been heralded as the seminal case, providing the tripartite analysis for courts to utilize when evaluating how much process is due. Okay, so let's talk about this whole due process thing real quick. Identification of the specific dictates of due process generally requires consideration of three distinct factors. First, remember, this is all about whether or not they should have been allowed to include their evidence that they were claiming was fraudulent, that the SSA said was fraudulent. First, the private interest that will be affected by the official action. Second, the risk of an erroneous deprivation of such interest through the procedures used and the probable probable value, if any, of additional or substitute procedural safeguards. And finally, the government's interest, including the function involved and the fiscal and administrative burdens that the additional or substitute procedural requirements would entail. Okay, so those are our three elements on essentially this whole idea of due process. Okay, being able to essentially give these people a chance to battle their case, provide evidence, and support a defense to show where they're coming from, or in this case, a plaintiff situation where they're trying to go after the government to say that they deserve their benefits. But in applying the Matthews framework, we must not forget the principles that anchor it. Procedural due process in the context of the government entitlements sought to ensure minimum procedural safeguards, which is Goldberg v. Kelly. Okay. The Goldberg court emphasized, we recognize the importance of not imposing upon the states or the federal government in this developing field of law any procedural requirements beyond those demanded by rudimentary due process. So what this dissenting judge is saying is that people should be afforded the very, very, least, the smallest amount of due process for the court to procedurally have to deal with. Okay. 6 years later, the Matthews court reaffirmed that in assessing what process is, substantial weight must be given to the good faith judgments of the individuals charged by Congress with the administration of social welfare programs, that the procedures they have provided assure fair consideration of the entitlement claims of individuals. Okay, so everybody's got to be fair in this, right? Fair in the application of due process. Give them a fair shot to prove things. Without saying so, Kirk and Taylor effectively reject these procedural principles. Doing so, however, cuts Matthews loose from its moorings, rendering it merely a court's subjective view of the underlying interests at stake, which is a fancy way of this judge is not happy with the actual application of Matthews in its sense of this particular case. Now, here's why. Thus, with these important principles in mind, I turn to the Matthews analysis here. Here we go. So here's his assessment and his ruling. And just so that everybody's aware of this whole situation, if you learn anything from this case, it is that you need to have multiple doctors supporting your claims of impairments. Not just one, not just this guy or this one specialist. You need to have multiple doctors so if they ever pull this with you and say, oh, there was a potential fraud. Oh, there's a potential fraud. Then in that case, in that situation, you have backup doctors to fall in on. Also, please remember to like and subscribe. Indeed. Okay. We look first to the private interest prong of the Matthews three-part test. In this prong, and throughout our analysis, it is important to keep our eye on the ball. There's only one constitutionally protected private interest: Kirk and Taylor's ongoing receipt of benefits, provided they are eligible. Okay. Social Security disability benefits have long been afforded this protection and undoubtedly should be. Okay. Now, do we technically constitutionally have a protected private interest? Technically, there's a 1937 Supreme Court ruling saying that's really just taxation. But they could claim that it truly is. But I think if we go back to the origin story with that Supreme Court ruling, there's argument against that. Okay. So just remember, it's not perfect. It's a gray area. Okay. Here, although there's only one constitutionally protected interest, there are numerous determinations made. 1, the OIG's reason to believe fraud determination. 2, as a result of the OIG's determination, the SSA's decision to redetermine benefits and exclude certain evidence. And 3, an ALJ's conclusion on Kirk and Taylor's eligibility for ongoing benefits. Kirk and Taylor seemingly mention these various determinations interchangeably with a goal of broadening their interest. They argue that the OIG's determination affected their rights because it triggered a redetermination hearing where they were unable to argue that the OIG had no reason to believe their template RFC form was fraudulent. So in other words, what they're saying is, okay, you think it's fraudulent, but prove it's not, which is an interesting situation. Just take a moment real quick. Imagine that. You have an attorney back in the day that's fraudulent, hiring doctors and paying them to fill out forms. They fill out the forms specifically for the limitations that the claimant is complaining about. How do you know the doctors weren't actually right in completing a form that was created based off of the impairments that the person was suffering from? Well, you got to look at it. You have to look at alternative evidence to see if it was supportive of the claim. But what happens when you don't have additional evidence and the claim was decided materially using that one RFC letter? Well, that's where you get into a shit show. That's what happened here. Okay, here we go. They argue that the OIG's determination affected their rights because it triggered a redetermination hearing where they were unable to argue that OIG had no reason to believe their template RFC form was fraudulent. The problem with this argument, however, is that Kirk and Taylor have no constitutionally protected property interest in those decisions or in avoiding redetermination for that matter. And, that's not an inaccurate argument because the SSA can do a redetermination when they look at things. Although in this case, they're going backwards in time to a too far back period, but they've got to do it because of the potential fraud. Now, they only have such an interest in the decision about whether their benefits should continue. As described more below, this failure of Kirk and Taylor to identify the proper interest infects their entire analysis. Further, even with their eyes fixed on the proper interest, Matthews requires more of the determining whether there is a private interest at stake. It requires courts to consider the extent of that interest. Several mitigating considerations reduce the significance of the interest here. All right, so what are the judges saying with this whole situation? Kind of like breaking it down. What interest do they have that is protected? Is the RFC form de facto fraudulent? Did the RFC form pass the sniff test to say that this could be potentially valid, or did it fail the sniff test and say, oh, this is definitely fraudulent? It's definitely fraudulent. First, Kirk and Taylor suggest consideration of their individualized circumstances. For example, they point to the specific economic hardships they have suffered from the redetermination of their benefits. Okay, so they've suffered during the redetermination, but if they were fraudulent to begin with, you know what I mean, that this is part of their crime. This is part of their punishment. But without disputing or lacking sympathy for Kirk and Taylor's circumstances, Matthews requires consideration of the categorical interest, not any one applicant's personal interest. And according to the Supreme Court, the potential deprivation from losing disability benefits is generally less than that of welfare recipients because eligibility for disability benefits, in contrast, is not based upon financial need. This is so because, eligibility for disability benefits is wholly unrelated to the worker's income or support from many other sources, such as earnings of other family members, workmen's compensation awards, tort claims awards, savings, private insurance, public or private pensions, veteran benefits, food stamps, public assistance, or many other important programs, both public and private, which certain provisions for disability payments affecting a substantial portion of the workforce. So again, their argument is, according to the Supreme Court, the potential deprivation, the taking away of your disability benefits, the loss of your disability benefits is generally less than that of welfare recipients because eligibility for disability benefits is not based upon financial need. Unless, of course, we're talking about SSI, and then the court here would be wrong. So to be fair, this dissenting judge should have done a little analysis more on that. But again, circuit court judges, they don't really know the programs of the SSA. And again, to be fair, there is a financial test as element effing 1 to decide if you are eligible for disability benefits. It is known as the SGA element of the 5-step sequential process, meaning element 1 is a financial needs test. If you're earning over $1,620 per month, you are no longer eligible for disability benefits in that month. So if we apply our little bit more knowledge than the circuit court judge realistically has, because he doesn't live in this field, we know that disability benefits are heavily, the first element is based off of financial need and financial inability to make more money. So let me read this sentence to you again. Think about it for a moment. Yeah. And according to the Supreme Court, the potential deprivation from losing disability benefits is generally less than that of welfare recipients because eligibility for disability benefits, in contrast, is not based upon financial need. I think the Supreme Court doesn't have an unhealthy relationship like I do with the Social Security Administration and its laws. So as a result, I think we can mostly agree that the Supreme Court effed up that ruling because obviously element 1 is the element that says, hey, they can't work anymore above this tiny monthly amount. And in order to get to element 2, you have to basically be unable to work. So, like, welfare people, yeah, I can see they got issues, but disabled people, now that to me is a much, much higher deprivation of benefits than welfare because you can't work going forward. Again, the Supreme Court doesn't live with Social Security like I do. So even the brightest minds in that field aren't always going to get it right. They get a lot of stuff right. They're much smarter than I am, but I live in this field. All right. Here's the deal. Thus, while the Social Security benefits Kirk and Taylor were receiving are entitled to protection, the private interest in them is less than that in benefits tied to financial need, which again is moronic. This judge made a mistake here. His dissent is broken. Similarly, Kirk and Taylor improperly emphasized that under the redetermination process, an individual applicant could be required to repay previously provided benefits. Relevant to this, the Act provides a procedure by which past overpayments may be waived, SSA 632 form, and 98% of waivers have been granted in Khan's cases. Indisputably, Kirk and Taylor have been already receiving waivers. Widespread waiver, not individual debt, is the proper categorical consideration. Additionally, applicants may submit a new application for benefits. I fully recognize this is an obvious difference in the benefits an individual may receive by new application. Okay. So, all right, let's go through this thing. Let's try and wrap it up here because it just goes on and on. In sum, as to the first of Matthew's factors, disability claimants in general possess a substantial private interest, which is not true. There's a lot wrong with this dissent. Like, to be honest, like he should have, if he just went back to 1937, he would have realized like his dissent is an issue here. All right, turning on to the second factor of Matthews, we again must keep our eye, blah, blah, blah. Wrongful termination of benefits. Again, that's wrong. This dissenting opinion, you know what? There's a lot wrong with this dissenting opinion. I'm actually a little bit saddened by what they did here. All right, so here's the bottom line. Okay, let's go back to the actual decision point. The SSA violates your due process. Okay, when it goes ahead and does not allow you to go through a process to figure out whether or not the RFC documentation should in fact be reviewed for the potential that was not fraudulent in nature. And that's not just these RFCs where they were pre-filled out and submitted. That's if you went to a doctor and the doctor, was potentially fraudulent. And, we don't know if that doctor in that case, in that particular situation, wrote fraudulent medical documentation for every single, patient that went in front of them. Okay. So in summary, what the majority decided here. Finally, the government's countervailing interests are weak, while SSA certainly had a substantial interest in preventing fraud and in avoiding erroneously providing benefits. Okay, that was Ching v. Mayorkas. Allowing beneficiaries to contest reason to believe findings would only advance that interest by helping the agency accurately determine which evidence is actually tainted by fraud and which is not. So to summarize, what happened was these individuals complained and bitched and said, hey, you just unilaterally took my medical records and said that I can't use them. And the SSA said, yeah, it's based on fraud. Go F yourself. Too bad. Sorry. I love you, but it is what it is. They didn't say go F yourself, but you know what I mean? They said, we're taking it out. We are removing it from the record. So sorry. So sad. These guys said, hey, wait, we got to be able to look at this. We got to be able to figure out this really is fraudulent. Nor would any potential burdens on the agency, whether financial or administrative, be significant. Contrary to SSA's assertions, there is no need for complex evidentiary hearings or mini trials here. Rather, a procedure akin to that used by federal courts to resolve a motion in Lamine would suffice, i.e., each side arguing for or against the admissibility of the allegedly fraudulent evidence, either orally or through briefs. So in other words, the majority is saying they need to have a mini hearing arguing for or against the use of that evidence going forward. What are the values showing that it is not fraudulent and should be used? or it is fraudulent in part but not in total and should be used, what are the arguments for completely restricting it from going into the record and being used? Okay. Next one. We also reject SSA's argument that allowing individuals to contest the fraud allegations would frustrate Congress's objective in providing for swift and efficient redetermination procedures. Like the Sixth Circuit, remember, this is the Fourth Circuit, and they're pulling from the sister circuits and how they decided. We deem this argument unpersuasive. The SSA is arguing that, well, in order to be quick and swift with these procedures, save a little money, get it all done as quickly as we can, we'll just schmoozy, get rid of it, and boom, keep going. All right. Quote, given that the SSA waited nearly 10 years after first learning about possible misconduct involving Khan and an ALJ Doherty to initiate redetermination proceedings, it seems disingenuous now to claim that the plaintiff should receive fewer procedural protections because the SSA is statutorily obligated to move quickly. So in other words, the majority said, SSA, y'all should have figured this problem out since you received a heads up and a significant load faster. The SSA should have been filing this problem, going after these redeterminations years before they did. Now that there's so many years down the line, they have restricted the ability of that claimant to prove that back then they were in fact disabled. Because getting medical evidence now is 10 years plus later. It's a different decade. It seems disingenuous now to claim that plaintiffs should receive fewer procedural protections because the SSA is statutorily obligated to move quickly. In other words, SSA, you effed up. You should have moved faster on this. We further agree with our sister circuit's rejection of SSA's argument that the additional procedures sought by plaintiffs would infringe upon law enforcement efforts concerning Khan's fraud conspiracy. According to the SSA, redetermination hearings that allow challenges to the agency's fraud allegations would likely rehearse the criminal case merits, including the government's theory and supporting evidence, thereby interfering with the prosecution of individuals involved in the fraud. Congress, however, has already provided the mechanism for ensuring that SSA redetermination proceedings do not threaten criminal prosecutions, where a prosecutor provides a written certification stating that there is substantial risk that conducting redetermination proceedings for a particular beneficiary would jeopardize the criminal prosecution of a person involved in a suspected fraud. SSA must halt the redetermination process. So basically what the saying is, if criminal fraud is going on, they halt the redetermination process and wait for the criminal fraud, case to get farther along or completed. Okay. If SSA, because there's points in those claims where it's like, okay, they can continue with the SSA administrative adjudication. If the SSA is genuinely concerned about the potential risk of frustrating law enforcement efforts, it should follow the statutory procedure rather than deprive beneficiaries of procedural protections. Therefore, we find that the third Matthews factor two ways against the SSA position, as each of these three Matthews factors weigh in favor of mandating the procedural protection sought by plaintiffs. We hold that the due process clause of the Fifth Amendment requires SSA to provide plaintiffs and those similarly situated an opportunity to contest the office of the Inspector General's fraud allegations as to their individual cases. By denying plaintiffs this opportunity, the SSA violated their procedural due process rights. We conclude that the SSA's redetermination procedures violated both the Administrative Procedure Act and the Due Process Clause of the Fifth Amendment. Therefore, we affirm in judgment in number 19-1989 and reverse in number 19-2028. SSA's prior redetermination decision as to plaintiffs are vacated, and we remand both cases to the agency for further proceedings consistent with this opinion. So keep in mind that what happens is now they go back, they send all this to a lower administrative judge at the SSA, right? The AAJs get it and they'll send it back to an ALJ. And what will happen is, at that point, okay, the ALJs will go ahead, an ALJ will have a hearing where both sides can say this is why the evidence is important and should be allowed. And then also, the SSA will be able to provide notification as to why they feel the evidence should be stricken from the record. Now, some of you are very smart and you're wondering, well, hey, wait a minute. these administrative law judges, they're like counsel on behalf of the SSA. Because remember, with these regular hearings, there's no opposing counsel to you getting your disability benefits. The opposing counsel, the closest thing we have, is the administrative law judge, because the administrative law judge questions you to collect testimony about what you're saying instead of being traditionally examined and cross-examined by counsel and opposing counsel. So the problem is we are handing over, essentially, to the SSA the right and the option of the SSA to argue that the evidence shouldn't be included and be decided by the judge who is essentially ruling on the claim to begin with, which is a weird way of double dipping into a very, very completely unethical, immoral way of adjudicating a claim pertaining to the cadre division functions of deciding if evidence should be included. Now, with that said, I will catch you all a little bit later. But what should you learn from this? You should learn that whenever you are found disabled, you have to keep going to the doctor. If you are going to the doctor when seeking benefits, go to multiple doctors. Okay? I don't care if it's the hospital reviewing the specialist. I don't care if it's a specialty facility where you're getting, unique specialized treatment. I don't care. See multiple doctors related to the same impairment. That way, the SSA, even if they claim some doctor is fraudulent or some document or some doctor is this or that, doesn't matter. You've got a backup doctor in your pocket. Okay. You got a backup doctor ready to provide evidence to say, yes, they believe you are this severe, this disabled, this whatever. All right. I will catch you all a little bit later. You have a wonderful, wonderful night. Attorney Walter Hnot, please remember to like and subscribe, and we will go from there. Have a wonderful, wonderful night. Also, if you get a chance, go into Google, type in Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there. We do these videos. I'm super tired, and it is 1:34 a.m. in the morning. With that said, I will catch you all tomorrow, where I'll be going live to answer questions for free Mondays and Thursdays. And also, I have a private session option below where you can hire me for an hour to go through some Social Security disability issue that you're having. With that said, if you need a disability attorney, call a bunch of them, but I am the most viewed and subscribed to and clicked on one. And I hope you have an amazing and wonderful day. And we will go from there. Attorney Walter Hnot, thank you so much. Disability Resolution PA. Have a wonderful, wonderful night. Thank you so much. Bye-bye, everybody. Bye-bye.